partners extraterritorial or not. And so we finally end, as promised, with a day that's looking at securities laws in itself and where it's going, and some alternatives in the future to the Morrison case. For moderating that, I have my colleague Paul Paton, who joined us from Canada. We found out this morning that that was a liberal place in many ways. One of my former colleagues was always planning to leave there during the Bush, to go there during the Bush administration. He kept saying, I'm moving to Canada. But it was a liberal place in terms of securities class action. And a place that we found out this morning was a sort of, I would use the term state, but actually province law, which will nicely segue into speakers that Paul will tell you about. Without further ado, Paul Paton.
Good afternoon. Thank you very much. Good afternoon, everyone, and thank you for sticking it out to the bitter end, particularly on such a nice day and on a Friday afternoon. I think in terms of what my colleague Frank has introduced and what you've had in the session today, it's particularly apt for me to be moderating this panel. I just wanted to take a moment to both introduce our speakers and also to frame, in the context of the work that I've done, some of the discussion that will end up coming. As you may have seen from the bios, I am director of the Ethics Across the Professions initiative here at McGeorge, which is a 10-year grant funded by the Sierra Health Foundation, and my own research and writing focus on regulation of the legal profession, legal ethics in corporate contexts, and the regulation of lawyers and accountants, key players in corporate governance. And in terms of dealing with securities regulation matters, I actually taught securities regulation in Canada. I was a professor for 4 years at Queen's University in Kingston, Ontario, prior to coming here, and had colleagues and friends who were actually chief enforcer of the Ontario Securities Commission come and visit with my students. So in that respect, at least, and one of my former classmates has just stepped down as head of the competition tribunal. And when we had two of our Ethics Across the Professions speakers earlier this term, one, David Vladek, earlier in the month, was director, he's currently at Georgetown Law, but was director of the Federal Trade Commission's Bureau of Consumer Protection, and spoke very directly about the necessity of cross-border cooperation in both investigation and in enforcement. In that context, he was talking about collaboration between U.S. authorities and the RCMP, the Royal Canadian Mounted Police, on a number of different issues in Canada. One most highlighted was the case involving MoneyGram and money laundering, MoneyGram being the number 2 behind Western Union in terms of wire transfers and the correlated problems with cross-border fraud. And so in that respect, it was interesting for me to have this invitation to introduce our speakers to talk about the ways in which transnational securities enforcement is going to take place. The Canadian context, this is a matter of constant debate. And the Conrad Black Hollinger International case in Chicago was a perfect example of what most Canadians thought of as cross-border reach and overreach by the Americans, and what Americans thought of as Canadians engaging in too lax enforcement. And so sometimes where you stand is where you sit. And when it comes to cooperation and collaboration, I look forward to hearing from our speakers about their perspectives. Katherine Florey, who's a professor of law at UC Davis, will be speaking on the missing piece, what's the role of state law in disputes with foreign elements. And Marco Ventoruzzo, who's professor of law at the Planck Institute, Penn State, a colleague of Laurel Terry, who we hosted here for another Ethics Across the Professions discussion in January about the regulation of lawyer conduct internationally in January, will be speaking on why the Morrison test doesn't work. Indulge me for a moment while I give you a bit of background on each one of them. Katherine is professor of law at UC Davis, received her A.B. summa cum laude from Harvard and a J.D. from Berkeley. Following law school, Professor Florey clerked for Judge William Fletcher of the U.S. Court of Appeals for the Ninth Circuit and was an associate at the firm of Kecker and Van Est. Her scholarship focuses on jurisdiction, choice of law, overlapping spheres of regulatory authority, and her articles have appeared in some of the most noted law reviews, including UCLA, Boston, and Notre Dame, amongst other journals. Professor Ventoruzzo is professor, as I've indicated, at both Penn State Dickinson School of Law and the Bocconi University in Milan, Italy. He's the director of the Max Planck Institute in Luxembourg, leading the Division on Listed Corporations and Financial Markets Regulation, has written extensively in corporate law, securities regulation, and is a member of the board of directors of the European Company and Financial Law Review, and serves on the boards of editors of other journals in the field. We're privileged to have both of them to wrap up this afternoon. Each one will be speaking for roughly 15 minutes, after which I will pose the first question, but I invite your participation at that time and would ask you to hold questions for both speakers until both have completed. Thank you very much, and let me turn it over to Katherine now.
Thank you. So I apologize. I'm losing my voice. My tendency to put way too much on PowerPoint slides may this one time work to my advantage. So I'm talking today about, we know what Morrison does. We know that Morrison explicitly scales back the reach of federal securities law. It also obviously entrenches and expands the applicability of the presumption against extraterritoriality more generally, suggesting that any federal statute will be subject to a similar sort of analysis, and thus limiting the reach of other federal statutes abroad. And that's certainly how lower courts have applied it. As Morrison did that, however, and as lower courts have continued to apply Morrison and the presumption against extraterritoriality, I think there's really one big question that's gone unaddressed, which is what happens to state law in Morrison's wake. Obviously, state law is a form of U.S. law, and Justice Breyer's concurrence in Morrison very obliquely alluded to the possibility that state law might step in to fill the void left by federal law in disputes with extraterritorial elements, but didn't express any particular stance toward that. And in many ways, state law and state choice of law methodology is really not particularly well equipped to deal with the kind of questions that a case like Morrison raises. And that will be the subject of what I'll talk about. So, both prior to Morrison and especially after Morrison, state law is often going to apply where Morrison says that federal law does not. And certainly with respect to securities law particularly, many state law fraud causes of action actually have precisely the same elements as the federal securities cause of action that was at issue in Morrison. Sometimes, for various reasons, it's harder to state a cause of action under state law because of particular burdens and presumptions. But if you're looking at a state law cause of action versus nothing, obviously, even a slightly inferior cause of action is going to be very attractive to foreign plaintiffs wishing to make use of U.S. courts. And the same is true for other areas of law that have been affected by Morrison. Federal RICO, which has been held by many lower courts to be subject to the presumption against extraterritoriality. In many cases, there are kind of state mirror RICO statutes that have, again, very similar provisions. So strong incentives exist for plaintiffs whose federal causes of action are dismissed because of the presumption against extraterritoriality to simply refile their cause of action immediately as a state one. And this actually a RICO case, Norris Petroleum versus Blavatnik. This is a case where the plaintiffs did precisely that. This is a kind of crazy case involving a Russian oil company that the plaintiffs alleged was sort of physically seized from them by guys with machine guns, and there was all this kind of crazy international intrigue. And this was a case that was dismissed in federal court in the second, and then affirmed by the Second Circuit, and the plaintiffs immediately refile in state court with an almost identical set of causes of action and a very similar complaint. That case was ultimately dismissed for statute of limitations reasons, but we don't know. It's clearly conceivable that a case like that could go forward. What about states, though, and extraterritoriality? Obviously there's a a well-developed federal law of extraterritoriality and more broadly, extrajurisdictionality and comity and potential conflicts with international norms. In contrast to that, in the federal arena, most states have extremely underdeveloped law. In fact, all states do, most of the time, in the majority of cases with foreign elements, is simply to apply their regular old choice of law principles to determine whether foreign law applies or whether the law of a particular state applies. And in most cases, again, not completely universally, but the vast majority of the time, states' choice of law methodologies treat the law of sister states and the law of foreign nations identically. So as one commentator put it, under the second restatement of conflict of laws, which is by far the plurality approach, it's about half the states use it in their choice of law analysis. To put it bluntly, as one commentator said, it does not matter whether the choice is between the law of New York and New Hampshire or between the law of New York and New Guinea. So there's this sort of provinciality, I think, often where state choice of law principles are involved. And this is particularly true when state common law is at stake. Sometimes when a state statute is involved, state courts will look to precedents involving federal statutes. They'll exercise some sort of equivalent presumption against extraterritoriality. But really, when common law is concerned, states rarely, if ever, do so. It's just not a concern that's triggered. The result is that states often do apply their law to foreign conduct and actors. Obviously, there are going to be issues with personal jurisdiction, with forum nonconvenience. Sometimes states will, in fact, apply foreign law. It's not a guarantee that state law will apply, but it happens fairly regularly that states do apply, most frequently forum law, sometimes some other state law, to disputes with substantial foreign elements. And a case in point is California punitive damages law under California choice of law principles, which rest on this methodology known as comparative impairment. California courts, in many instances, are nonetheless often pretty aggressive about applying California law. And where punitive damages are concerned, for example, many courts have said there's a strong presumption of in favor of applying forum law, California law, particularly where there are no foreign resident defendants. So if the defendants are not based in a foreign jurisdiction, California courts will almost universally apply California punitive damages law, saying that that jurisdiction has no interest in applying its own law. Sometimes even when the defendants are residents of a foreign jurisdiction, courts in California have nonetheless applied California law, reasoning that because they are not creating a new obligation on those foreign defendants, but simply increasing their exposure to damages, no particular sort of comity or extraterritoriality concerns are raised. So certainly this is an instance where foreign defendants or people doing business in foreign countries, their exposure may be vastly increased under California law. This raises the question, of course, of why state courts have been doing this. Why haven't they followed this trend where federal statutes are concerned? And I think it's really, the explanation has to be the context in which state choice of law doctrines evolved, which is really to deal with these sort of minor differences between the law predominantly of sister states. Guest statutes and interspousal immunity, all these issues that are fairly small in the grand scheme of things, and that while they may matter to individual litigants, really don't matter that much in terms of sort of being cornerstones of state policy or the policy of a foreign nation. In the grand scheme of things, they simply don't matter that much. So that's one of the reasons. The other main reason I would suggest is that because the presumption against extraterritoriality focuses so much on congressional intent, there simply isn't an equivalent when we're talking about state common law. So those doctrines are not readily applicable to the state context. Finally, constitutionally, states are subject to only extremely modest limits in their ability to apply their own law. So states are accustomed to basically, doing what they want, assuming that unless the application of state law is really far-fetched, it's not going to trigger any constitutional concerns, and there aren't any other kind of meaningful limits on what states can do in the context of making choice of law decisions. So I would suggest
Katherine, leave that to me. I'll get it on here.
Okay. There are a few different implications of this, and one piece I think has to do with Morrison. I would argue that the potential applicability of state law in situations where Morrison means federal law doesn't apply undermines to some extent what I see as the two main rationales of Morrison. First of all, Morrison and other cases interpreting and applying the presumption against extraterritoriality focus on this idea that they're really an attempt to effectuate congressional intent. As the court said in another case applying the presumption against extraterritoriality, the presumption, quote, led us to the same conclusion that the 79th Congress would have reached had it expressly considered the question we now decide. So there's real sense that the court is stepping in for Congress, trying to interpret congressional intent, and that the presumption is one means of doing so. I would argue that the fact that state law may often apply where federal law doesn't calls that into question, because even if Congress is wary about the application of U.S. law abroad, it's dubious that Congress would really have wanted to substitute state law for federal law, that is an effect that Congress would have wanted. And indeed, if state law and federal law are in a particular balance with respect to domestic disputes, whether explicit preemption or a more implicit idea that federal law is kind of setting a baseline standard, that Congress would want that same balance to apply to disputes abroad. Second, the court has suggested that as a matter of policy, we want to discourage foreign plaintiffs who are seeking to take advantage of, this Shangri-La of liberal discovery rules and liberal damage rules that prevails in the United States, and really exploiting American courts. Again, if that's part of the point of the presumption against extraterritoriality, it's not clear that it's necessarily going to be effective if actions can be brought under state law in place of federal law. So what should be done given these realities? I would argue that principles governing extraterritorial application of state and federal law should be better aligned in two directions. First of all, the presumption against extraterritoriality should perhaps be applied with more nuance, taking into account when deciding why and how to apply the presumption, what the application of the presumption is going to do to this balance between federal and state law abroad. On the state side, I think the opposite should occur, that states should be less willing to apply their law to disputes with foreign elements, and should develop choice of law methodologies that can take into account the distinctive issues raised in disputes with foreign contacts, and address some of the comity and extraterritoriality and issues of sort of conflicting regulation of particular actors that may occur when foreign contacts as opposed to wholly domestic ones are involved. So I would suggest that both federal choice of law involving federal questions and choice of law involving state law have some way to go, and that a more desirable state would be to bring them a little more into harmony. And so with that, I'll
Great.
turn.
Thank you very much indeed.
Thank you very much. I have to say, very pleased and honored to be here. I'm pleased, first of all, because 48 hours ago I was in Luxembourg with 2 inches of snow, and now I'm here in this wonderful sun. And I'm also very pleased because before I was looking for the restroom, and someone in your staff asked me if I was a JD, and I was there for an interview. And I have already reached that age where that kind of comments really flatter me, so that has created a never-ending love for McGeorge. But I'm also honored because it's really a pleasure to be in a school that has such a strong focus on international and comparative law, and that, without being myself flattering, I have to say, is largely due to the efforts of Frank Gevurtz, who is, I can see him now, I'm trying to embarrass him, so I would like to see his face, but he's really a legend among those of us that do comparative and international issues related to corporations and securities regulation. I'm perfectly aware that I stand between you and the end of a very interesting but also intense day in which we have dissected any relevant aspect of the Morrison decision and more generally the issue of extraterritoriality. And speakers before me have illustrated and critically discussed much better than I could ever do both the theoretical and practical aspects of this decision. So as a strategy for my talk, I will follow what an old mentor of mine said at a conference many years ago. If they ask you to speak for half an hour, speak for 15 minutes and the audience will love you. And I will actually bring this theory to the extreme and just offer some very, very brief remarks concerning one of the flaws that I see in the so-called transactional test envisioned by the Supreme Court, and also a modest proposal for a different test. And I think I can promise that it will be around 10 minutes. I apologize if I will not go into the technicalities, and also if my proposal is not really based on textual interpretation or case law, but is rather what in civil law countries is sometimes referred to as a de jure condendo proposal, which means something not based on current regulation, but rather a proposal that on what the law should be. And if you're interested, of course, you can find a more detailed discussion in my article. As we all know, and as it has been discussed today, the conduct effect tests have proven to be very problematic. The two major criticisms were that it's too vague and too broad. On the one hand, determining uncertainties, and on the other hand, leading to an aggressive assertion of jurisdiction also on cases that have little to do with the United States. I think that both criticisms are fair, but I also think that the transaction test introduced by the Supreme Court might present similar problems. Even if by now we all know it by heart, it is worth reading again the definition used by the majority of the court, which I have quoted here. Section 10b reaches the use of a manipulative or deceptive device or contrivance only in connection with the purchase or sale of any securities listed on the American exchange, an American exchange, and the purchase or sale of any securities in the United States. Despite its appeals to the need for a bright line rule, the Supreme Court does not seem to clearly and unequivocally define what constitutes a purchase or sale in the United States. When does a purchase or sale occur in the United States? There are, I think, two possible readings of this formula. A narrow reading suggests that the contractual obligation to buy or sell securities must have arisen in the United States. If I'm not mistaken, it should mean that the contract, and someone referred to this before, must be executed in the US for Section 10b to apply. If, however, this is the correct interpretation of the transactional test, it is difficult not to agree with the opinion signed by Justices Stevens and Ginsburg, according to which the new rule might leave some American investors out in the cold. Consider the hypothetical used also in the concurring opinion of an American citizen resident in New York convinced by another US party to buy securities of a closed corporation incorporated and doing business in the US on the basis of false and misleading information. Negotiations take place in New York, but the investor is flown over to Venice, for example, in my home country, to sign the contract. Applying the narrow reading of the Morrison test, this investor could not invoke the protections offered by the 1934 Act, and this outcome cannot, I think, be considered in line with the goal of the statute. The only logical, probably alternative then would be to read something more into the second prong of the transactional test. If, however, the expression purchase or sale of any securities in the United States can be expanded to include situations like the one I just described, I'm afraid that we would be back at square one by giving relevance to the conduct of the defendant or to the effects of the transactions. In other words, and in short, I posit that the transactional test leaves us between the rock of a literal interpretation, which would lead to absurd consequences, and the hard place of a more flexible reading, which would reintroduce some of the uncertainties, if not all the uncertainties, of the conduct's effects test. I propose, therefore, what I have called a revised effect test, which in a way means to go back to some older decisions with some new elements. The test I propose is fairly simple, probably maybe simplistic, and it's that the illegal conduct created direct, substantial, and reasonably foreseeable consequences in the United States. In other words, it's going back to an effect-only approach, even if slightly qualified. Some ideas to try to convince you that this might work better than the transactional test. The language is somehow borrowed both from older securities cases, but also from antitrust, and even if this is not at all my area of expertise, I understand that it is a test that in this context has been used with some satisfactory results in the field. Second, I think it would reduce at least the uncertainties of the conduct test, which, to my understanding, was probably the most problematic part of the conduct effect test, even if after the Dodd-Frank Act, the Securities and Exchange Commission and the Department of Justice could still take action in cases in which only the conducts occurred in the United States, so that would not create the risk of the Barbary cost for securities litigation. Third, I don't think that there's a risk that it expands jurisdiction too much, and this is something that has been discussed also before Morrison was decided, because courts have some instruments, and this also has been mentioned today, to reduce this risk. First of all, class certification, and in particular the superiority requirement, might help to keep at bay some foreign cubed class actions that have no connections with the United States. I'm sorry if I go so quickly, but I want to keep my promise. Another point is reliance. As we all know, generally the fraud on the global market theory has not been really accepted by US courts, and this also might help to keep away foreign investors that are trying to exploit the American system of litigation. And also, which has been mentioned before, forum non-convenience might be a pretty powerful tool to dismiss certain cases, especially when there are alternative protections in other systems, such as it might be the case with the Dutch settlement system. Finally, even if the situation in Europe is very different at a number of levels, it seems to me that this kind of test would be somehow more similar to Regulation 44/2001 of the European Union, and this is something that might enhance the chances of an international agreement on the issue of jurisdiction in securities fraud cases. Some friends and colleagues have told me that this approach would in fact reintroduce some of the ambiguities of the effect test, and I totally accept this criticism. I just hope to have convinced you that it would strike, I think, more reasonable middle ground between the frankly chaotic and complicated situation before Morrison and the possible bizarre consequences of Morrison. But the best way that I have to get some credibility is to keep my promise to speak very briefly, and therefore I will stop here and thank you.
Great. Thank you both very much for quick tours through some very complex areas and complex concepts. One of the things I want to do actually with both of you is step back and actually ask about the political effects. You may have had this discussion earlier on, but Katherine, in particular with yours, although it's a thread that runs through both, having spent some time in government one of the things that I was always very conscious of whenever you talked about extraterritorial reach was the pragmatic effect of attempting to constrain, in particular, local actors in that regard. And what you're suggesting, I think, has real resonance in a very strong state-centered federal system like the United States. Canadian contrast, there is no national securities regulator, and so we actually have these discussions all the time about what's Quebec going to do and where is the British Columbia Securities Commission, because trying to get 13 voices to speak as one isn't quite as complex as maybe 50-51, but in that regard at least, what you're pointing to is a huge problem with which other federal states are already familiar. What do you think is the practical impact, or how can you see that being constrained? I mean, your suggestions are very practical in terms of what ought to happen. What do you think is the right approach to getting there?
Well, I mean, I think there are really two ways to go. I mean, one is some action by Congress to, somehow preempt state causes of action, or indicate that allowing certain sorts of state actions to go forward would be contrary to federal policy. I think a much more indirect and possibly unsatisfying but more important project long term is to alert states to this possible dimension of their choice of law decisions, because this is something that affects not merely securities law, but potentially many other areas. And I think it's increasingly the case that state courts are asked to address these questions. I mean, especially the courts of California and New York, I mean, to a really disproportionate degree. So one place to start might be trying to convince either the courts or the legislatures in that state to develop either judicial or legislative choice of law principles that take the foreign dimension into account more fully.
It's interesting in terms of the focus and the impact on California and New York. I somehow think it's a different dialogue in Texas, for example, or Arkansas, or other states in the South in that regard. But it points another thing to, in that respect at least, Marco, to one of the key questions that for me emerged out of your presentation is, what's the cost of ambiguity? Mm-hmm. And where do we in terms of the certainty versus ambiguity dimension of what you were suggesting, the proposed test is an attempt to to solve or respond to what you've identified as absurd consequences. But can we live with uncertainty?
Well, for sure it raises costs, and my sense is that concentrating on the effects might reduce some of the ambiguities, also because the parties have ways to try to avoid that a certain transaction plays effect in one country, such as, for example, as it happens with offers all the time, exclude U.S. investors from the offer, or other ways to avoid at least what I've called reasonably foreseeable consequences in one country. And in that respect, I think it might help in reducing some of the ambiguity from the point of view of the financial operators. It's for sure it will remain some degree of ambiguities will remain whenever we talk about we look at the effects. When I talk about effects, I'm mainly thinking about either the execution of the contract or the damages caused by the illegal conduct. But my sense is, going back to what I was saying before, is that it was really the conduct prong of the test that caused most of the ambiguities, because it's very easy on the one hand to assert that some conducts at least were carried on in the United States.
Thank you. Sir.
So Marco, I'm very sympathetic to an effects approach here, but I wonder how you would locate effects in the securities context. Do you locate them by where the investor is? And if so, doesn't that sort of shade over into passive personality, which is something which international law has traditionally distinguished from effects?
No, I think you're right. What I'm thinking mainly is are the damages caused to investors that are either, I would say, citizens or resident of one particular country. So in that sense, I think it would translate into passive. But still, I think it would be to some extent easier to assess. if in and it would also correct this the hypothetical I made before. You have the U.S. investor bring over, or someone, maybe you were saying, you know, they have a phone call and we have to decide whether the contract has been executed depending on who said I accept on the phone, or yeah, exactly. So in that respect, you could overcome that problem, because if you can argue that there were damages caused to a resident that is, I would say, either a citizen or a resident of one particular country, that country as a jurisdiction.
I mean, I think you're absolutely right that there are problems. There's a lot of uncertainty about where you locate transactions in unlisted securities, and it may not even make sense to think of a geographic location for them at all, because they don't, nothing ever gets physically delivered or done. So Morrison may establish a bright line for listed securities, but it's a mess for unlisted securities.
Yeah. Other questions, sir?
Well, that actually is an important caution for what I was about to ask. But if you just take the citizenship or domicile of the investor, if you think that the thing you are mostly worried about is the effect on the integrity of your capital market, then it really shouldn't matter who it was that was deceived by the false statements, because then the harm done in terms of withdrawing from that market because you don't trust it certainly doesn't correlate with the question of whether it's U.S. or foreign investors. So on that alone, it seems to me that can't be the whole issue.
Maybe one partial answer, however, is that, as I've briefly mentioned, the Securities and Exchange Commission and the Department of Justice still would be able to bring an action only based on conducts. And so, if I understood correctly your point, it's that would avoid and would help maintain the integrity of the market, but the action based only on conducts would be in the hands of the government, basically, which to me seems less problematic than to give it to private plaintiffs.
Well, in a way, that's what 929 does to some of the effects of Morrison. But if you are looking at the need for a private action as an important policing supplement to state action, I admit it's a fading concept nowadays, but it still, I think, has some power in terms of budgetary concerns, just look at the SEC. Then that alone doesn't cut it. But your point about the fact that so much of the trading takes place in what you might simply call non-located markets does make this a problem.
So many of the derivatives, right, which are clearly securities, but they're not, they're not listed anywhere. They're just dreamed up by some overpaid investment banker.
We won't get into the debate about the payment levels of investment bankers these days, but Frank next.
Let me follow that up, and then I had a question for Katherine as well. And that is that I was going to pose some hypotheticals for Marco in terms of the effects test, and it also goes to this question about focus. If you go to effect and focus on what the purpose was, then you get to several arguments. You get to Merrick Fox's. It's really an attempt to promote corporate governance and management of the company who's committing the fraud approach. Or you get to the sort of lemons market problem, where in fact it's all the companies that are not committing the fraud who are actually the victims that we're concerned with. And in fact, in that case, if an American company could have somehow sold more stock but for the fraud, so I worry about now you're trying to pick that up like a direct and substantial, but I thought as the conversation started to go, it does start to get to be a problem. So I'll let you comment on that, and then I'm going to have a question for Katherine.
Again, maybe one also possible answer to consider. Again, I understand it's not conclusive, but is that also other countries would have instruments to prosecute fraud generally. So even if you take out the cases in which there are no effects in the United States, but the effects are only in France or Spain, we can assume that in those countries investors would have some instruments, and especially if they all adopt